The appropriation is approved. All right, next order of business. Mr. Silver is going to update us on legal issues.
Do we have something to do with the floor machine?
The floor machine was included. It was $700.
Ah, okay.
Snuck it through.
I'll note it there, okay. Okay, all right. I've been asked to give a report on legal matters, status of legal matters. In the early summer of last year, the convention appointed a committee of investigation pursuant to RSA 2417, 2418. Although initially comprised of 5 representatives, after careful review of the applicable laws, it was determined that the committee could not be comprised of more than 3 members, so the membership was adjusted. Current members of the committee are Representatives Comtois, O'Hara, and Silver. The committee met on July 7 and August 23 of 2021. The only business conducted was a unanimous vote on August 23 to engage counsel to represent the committee, and that engagement was effectuated. Since then, the committee has been dormant. Total legal fees and expenses incurred to date by the committee was $120. Now, we move on to the Gunstock Area Commission litigation. On November 11, 2021, the law firm of Divine Millimet filed a lawsuit in Belknap County Superior Court, naming as the plaintiff the Gunstock Area Commission and as the defendant the Belknap County Convention. The suit sought injunctions against the convention in the nature of a temporary restraining order, a preliminary injunction, and a permanent injunction, all of which sought to enjoin the convention from removing from the GAC Commissioners Kydash, McClare, and Gallagher, notwithstanding that the enabling statute for gunstock passed in 1959 expressly granted to the convention the power to appoint new commissioners. Although brought in the name of the GAC, the suit actually sought to protect the status of 3 individual commissioners at the apparent expense of the GAC. As a result of the filing of that suit, the convention voted to retain counsel to defend it at its meeting on November 16, 2021, which is 5 days after the suit was filed. As an initial matter, the court denied the request for a temporary restraining order without waiting for a response from counsel to the convention. Thereafter, and after the filing of various and sundry legal papers and briefs and the conduct of extensive oral argument, the court denied the request for a preliminary injunction, noting in its order that the removal power was expressly granted to the convention by the enabling statute. Further briefs and motions and replies to motions were filed, but ultimately, after the composition of the GAC changed and it voted to discontinue and withdraw the suit, on March 1, 2022, Commissioner Ness sent an email to an individual believed to be the managing partner of the Divine Millimet firm, advising and directing that firm to discontinue the lawsuit. But the suit continued in active status until Commissioner Ness, newly elected as the chair of GAC, sent a further notice to the Divine Millimet firm on March 24, directing it to discontinue the suit once again. Finally, the Divine Millimet firm filed a motion for a voluntary non-suit dismissing the case with prejudice the next day on March 25, which was approved and ordered by the court on March 28, 2022. We now get into the area of legal fees. Although copies of the Divine Millimet fees to the GAC were requested under 91A, production of them was refused by counsel on the grounds of a claim of privilege. But proof of payment by the GAC to that firm of $94,150.62 through the payment dated January 27, 22 was provided. It is reasonably assumed that the January 27 payment covered a bill for the month of December, so it's also assumed that additional bills and payments for the months of January, February, and March will ultimately be delivered with the estimated total legal fees of the GAC estimated to be in excess of $100,000.
That is correct.
Legal fees and expenses incurred by the convention in the defense of the suit total $40,827.50 for the time charges incurred through February 28 of this year, with additional charges for the month of March to be determined. Of those sums, the county commissioners have paid $20,000, being the amount initially authorized and appropriated by the convention in authorizing the engagement of counsel. Thus, the present balance due is $20,827.50. In order for members of the convention to understand more fully the activities of counsel to the convention in defense of the lawsuit, I hereby move that the convention waive on a strictly limited basis whatever privilege that may attach to the billing statements of the Cleveland Waters and Bass law firm to the convention for the sole purpose of providing unredacted copies of that firm's bills to the members of the convention, to allow members of the convention to have pertinent information pertaining to possible failed payments to that law firm, with the unredacted copies of such bills to be held in confidence and not to be disclosed by any member of the convention without further action of the convention. And I ask for a second for my motion.
I'll second.
Okay. Any discussion, I guess?
Discussion on the motion. Representative Lang.
So, absent the fact we have absolutely zero lawsuit pending right now and zero legal actions pending, why does it need to be a limited motion to only allow members to see and not the general public to see what we spent $40,000 plus on?
The council has advised that a blanket waiver of privilege would be inappropriate and not in the best interest of the convention.
Didn't answer the question.
Representative Boyd.
So we as a committee approved $20,000 for this legal. We ran up $40,827.50 today. There's more bills coming. Who approved this and why is this happening?
Legal bills get out of control. We've seen it previously in this body, in the county. What is thought to be a simple matter gets extended, particularly when you're the defendant and you have to answer to various charges.
We appropriated $20,000 where we did more than double that in legal fees at the moment.
Correct. Further questions? Representative Tryon.
So, again, we did approve the $20,000, but when we saw that was gonna go over, before we proceeded any further, shouldn't it have come back before the delegation to take another vote, to spend more money before we incur these extra fees?
We approved the engagement of counsel and the engagement letter, which was approved by the signing by the delegation, by the convention, did not have a cap, did not have a limitation. And in a situation where we are the defendants, there's basically no way to control what we have to answer when the control is in the nature of the plaintiffs control the pace of the litigation. The normal strategy is for plaintiffs to make it as painful and expensive as possible for defendants to defend themselves. And that's basically, in my view, what happened in this case. Whether or not we should have come back when we saw the bills going over, I don't know the answer to that question.
Representative O'Hara.
So, either for you, Mr. Chairman, or Mr. Silva, I'm just reading the email from Attorney Gold, and at the bottom he said, please direct questions to Representative Silver or Sylvia, since they're supervising and directing us. Couldn't you direct them to maintain under the $20,000, or at least let us know we need to appropriate more money for that?
These defenses, they go along at the speed of the court and of the person bringing the charge.
All up there, but we noticed on our first invoice, we were halfway already to our balance. Our first invoice was $6,500, ending in November. Really halfway through balance. Next invoice in January, $36,000. No one was anticipating that to go over. When in November it was $6,000.
I think our assumption was advised that there is a contingency fund available to make payments for expenses like this, and that we would come back to the convention for a vote to approve the payment. I have copies of all of the bills unredacted, along with a cover memorandum from council for every member of the convention, if this motion passes.
Representative Lang?
So I guess I'm a little confused because we formed an investigative committee, and the original reasons we formed the investigative committee was because the county commissioners overexpended a line item, and we thought it was malfeasance. And so therefore, we decided to do an investigative committee to study the commission, to investigate the commissioners on malfeasance, and that was on a food line item, if I'm not mistaken, for the nursing home, to feed the people in the nursing home. Here, we have a clear vote of the delegation of $20,000 appropriation. We have a clear over expenditure. We've met since then, and it was never brought up that we needed to have more money appropriated. How is this any different?
I have no answer. Please. Representative Ward?
So the only way you're going to provide these unredacted statements is if we approve your motion.
Well, that's what the motion is.
The motion is to,
That's what it is.
it's not to pay the bill, it's just to give us the information we're asking for.
Are we ready for a question?
Just a question.
Pardon?
Just the motion.
The motion.
Can I ask a question first? My question is, you said that first invoice was $6,500, and then the next invoice went right from that to $36,000.
That's the
Well,
two
how do
items.
you stop, the question is to you, if that's legit, how do you stop that when you don't know? It went from 6,000 to 36,000. What do you do, call them every day and say, we did it? We did it?
No, but when two people are contacting the lawyer, they know how many times they're contacting them, they know how much they're racking up.
Follow up.
No, they don't.
Then, you know, the court has something to do with that, in my opinion, whatever it is.
How did you call this? Their bill, illegal.
Representative Flauget?
Well, we agreed, if this motion is agreed to and passes, this is, information is just for the delegation convention, I assume. Okay, now, by our vote, we're going to be held to that. No signatures, nothing like that. If it does get out.
After it's out? I don't know. I suppose
There's no recommendation or
the
nothing.
delegation could make a motion to release it to the public. I don't control that.
But, I can ask again, and you do not control the 17 members, what they do with that.
Well, the motion includes confidentiality. We hope, you are an honorable member of the general court. There is assumption that you will stand by that title.
And if it passes, thank you.
Representative O'Hara?
Just a quick question, whatever happened to our transparency then, to the people that with their money? I'm just, don't get why we have to hide the invoice from the people that they paid.
Representative Shanko?
Thank you, Mr. Chair. Just a question, and, because this is a legal matter. We were sued as a delegation, okay? We did not do any actions as a body to initiate a lawsuit. We defended ourselves. My question is, and maybe you can answer this, Representative Silver, is that, due to other factors, is it important to keep this confidential?
My understanding is that in order to get the initial $20,000 paid, our council worked with counsel to the county commissioners and provided redacted bills, at least some redacted bills, to the county commissioners, and under some type of agreement to keep those
Can you
redacted
do
bills
something with the
confidential.
sound? We can't hear with all this background
There's no
noise.
noise. We can hear
It's
fine.
really difficult to follow this.
Redacted copies of the bills were provided to the county commissioners through, and the county administrator, with my understanding being that there was some type of agreement with council that those bills, even the redacted bills, would be kept confidential. Yet the next time those appeared, they appeared in the letters column by the wife of one of the commissioners commenting on the redacted bills and appeared in the public record, notwithstanding the prior agreement that these would be kept confidential. The problem with legal bills that show complete narratives, just like the law firm for the GAC claimed privilege and did not want to disclose their bills to the convention or to me, because the narrative of the bills disclose who's talked with whom, discloses strategy discussions, and it discloses the thought processes of counsel, which are privileged and work product. So that's why there's a concern about keeping these confidential, because we received in the interim, in the last week or two, emails from several members of the convention indicating that they were unwilling to vote to pay any further legal bills without seeing the unredacted bills. So we asked for council's guidance, and we got the council's guidance on how to proceed, which is what the proposed motion is.
Representative Harris.
So does that council guidance increase this bill even more, or is that 40,000 that we're at now?
I don't know, I haven't received a March bill yet.
So we could be much higher.
So let me just say that with the bills that will be received after this vote, there's a cover letter from the attorney. Attorneys are very hesitant to release information. Frankly, I'm all for transparency. There's nothing to hide in those that I know of. So I'm just fine with it. But you don't know what the attorney, your attorney, says until you read the letter. So it would be pretty good idea for us to understand what the attorney believes, as opposed to arguing about how it got to be where it is. Representative?
Could we amend the motion so that it's not private, it's public information? I'm all for transparency, and this is against my grain. I think that it could be amended. I don't know exactly how to do that.
I would say that you need to read the attorney's letter and then come back with a motion to make it public. That's fine.
Later on, later on tonight.
You're here, you can do it tonight, you can do it next week, whatever.
I don't know what's in the letter that they shouldn't see, but that's.
Representative Lang.
So I just want to clarify something that Representative Silver said, and that was that the Superior Court has dismissed the case with prejudice, meaning it can't come back.
Correct.
Which means that the product we have is kind of irrelevant. We can't bring the suit back, so privilege doesn't really apply. I mean, in terms of we can waive it, because again, the case isn't coming back. We don't have to hide anything. We don't have any defense strategy. We're trying to protect, because there's no case and there's no chance for the case to come back. So I'll join you, Representative Bean, if you make a motion to make the invoices public, I'll join you in that motion.
Now, or later.
Let's take a look at it, and then after let's vote on this. I think we should all see what's in there, but then if you make the motion to make it public, I'll happily join you.
Representative Huff.
Yeah, I just want to throw this out here. It sounds to me like everybody's getting caught up in something that doesn't need to get caught up in. Basically, our lawyer is telling us that if we want to read it, which is what some of us want to do, then it has to come in this way. So we get it, we read it, and then if you want to give it to everybody else, do it. Can we just move along?
All right, I will, if we're ready for the question, clerk will call the roll.
Did we finally get the reread of it?
Yeah, I need to read the question.
I stated as motion to allow unredacted copies of the delegation only to be kept in confidence and not be shared with the public. That's about right?
All right.
All right,
Those are my.
you all ready? Call the roll. Representative Howard, did you get the motion? Okay,
You want me to vote?
Yes, I do.
No.
Okay. Representative Aldrich,
Yes.
Representative Boyd,
No.
Representative Bean,
yes.
Representative Harvey Hillier. Yes. Representative Huff,
Yes.
Representative Johnson,
Yes.
Representative Lang,
Yes.
Representative Littlefield,
Yes.
Representative Mackey,
Yes.
Representative O'Hara,
Yes.
Representative Bourget,
Yes.
Representative Silver,
Yes.
Representative Terry,
Yes.
Representative Chartier,
Yes.
Representative Barney,
Yes.
Representative Comtois, yes, Mr. Chair.
Yes.
16-2, motion carries.
Pass those out.
Terry?
Representative Silver is not yet included in the report, or what are we doing right now? Because I want to make a motion. I have a question, but I also have a motion. The motion is unrelated to the question. It's fairly simple. May I proceed with the motion? I move that Representative Silver's written report be made an appendix or an attachment that was included in the minutes of this meeting. Whatever the custom is, I don't know whether you call them attachments, appendix,
I
or
already
whatever.
have it attached.
Okay,
It's already in my.
that's my motion.
It's already in my.
Thank you.
Doesn't have to be motion.
All right. Without objection, the comments from Representative Silver will be attached to the minutes.
Then may I proceed with my question?
Yes.
Representative Silver, you mentioned two different legal matters, as I recall. The first was the investigative committee.
Yes.
With respect to the county commissioners, I believe that you indicated that you had two meetings, one in July and one in October of last year, is that correct? August. And that since then, the commission, investigative commission has been dormant. Are you at liberty to disclose to me and to the delegation and the public a reason that the investigative commission's work has been dormant for a number of months? And the second part of the question is, if you intend to awaken the work from its current hibernation, dormancy, can you give us an indication of when you intend to do so and under what circumstances?
Mr. Chairman, may I respond?
Yes,
The commission, the investigative committee was not, it's under statute, it doesn't limit itself to investigating the county commission. It investigates county operations on a general basis. After the engagement of council, we almost immediately got sued by the GAC, and our attention was diverted to defending ourselves in a lawsuit against the GAC. Now that the GAC lawsuit has been ended with prejudice, it's my intention as the chair of the investigative committee to bring it to life again and to then focus on those areas of county operations that we deem appropriate to investigate.
All right.
Point of order, please. Mr. Chair, earlier in the meeting, you opened it up for public comment on the appropriation. Are you planning on doing the same thing on this issue?
I was not planning on opening the public for this particular part. We have members who are looking at the bill and interested. I will open it to the public. Go ahead.
So if I'm listening to this discussion properly, if I put in a series of right-to-knows against the delegation to see though the paper trail between the delegation and its attorney, I will be denied, even though several of the delegation have said that they are for open and transparency. Given that the lawsuits have been dropped, I would think that all of that should be public information. After all, we're paying for it. So as a member of the media here in Belknap County,
I would like an answer as to why you would not open them up.
All right, we are in public comments, so your comment is taken under the advisement. Any further comments?
Ruth Larson, Alton. I would like it to be on record that among the comments, among the items in the redacted bill, which was carefully redacted with white out or whatever, which, by the way, I obtained indirectly through somebody else's right to know request, just in case I'm the wife of the commissioner referred to. Anyway, in the redacted bill, there is reference at one point to removal of Gunstock Commissioner Gary Kadash, and I would question what that exactly has to do with defending a lawsuit brought by the GAC, or whether that isn't venturing into uncharted territory, consisting of the delegation's leaders' vendetta against certain members of the GAC.
Thank you for your comments. Further comments? We'll close public comments.
Make that motion now. Make it public.
I'll second that motion.
So that you can, that you should do it as public.
So, Representative Bean has a motion to make the document public. Is there a second? Representative Lang. Question.
There's a senator trying to speak here.
Thank you for pointing that out. We are in the middle of motion.
So, may I direct a question to Representative Silver? At the bottom of the page, the confidential memorandum, the cover, there is a statement here to the effect that we would keep the following in mind to minimize the risk of loss of convention's legal protections. The first is much of the information in these invoices is protected by law from disclosure. Is that, first, is that conditional, or is that unconditional, that statement?
The attorney-client privilege and the work product privilege are not, they're conditional only on keeping it and not disclosing it. If the information is disclosed, the privilege is waived.
So what would be the impact of our making the unredacted invoices available to the public in full?
I have no idea.
You don't know what the legal implications would be?
No.
Representative Conflict.
Thank you. So if we vote to make these public, yet the GAC still has invoices and bills that the public has not been able to see, because they are redacted, that affects this particular case. I mean, is there, would there be an issue there?
Representative Silver.
The invoices from the Divine Millimet firm to the GAC have not been produced in redacted or unredacted form, in any form. All we have are copies of checks payable to that firm.
Representative O'Hara.
So I just wanted to just try and understand the point of this. We're discussing releasing our invoices that they paid so they can see what they paid for, and what is the concern that could happen? Is there any, it's a serious question, any like legal concerns that you have? Serious legal concerns?
Every lawyer that I've talked to says you don't release it. Personally, I'm all for it. I'll vote to release them. I don't see any problem with it. Representative Bean.
Isn't it true that no matter what's in there, if we get in trouble again, they're gonna have to pay for it? They may as well know it now, in my opinion.
Representative Cloutier.
I read the cover page, I looked through it. I would like to actually analyze it. We along, what is the reason not to hold on to it and make sure we actually know the repercussions of what's in here, if there is any? We can always come back and release it. My question might be is, does the public need to know the same day we have it? It's gonna take me longer to understand this than it will be out in the newspaper and the repercussions of that. I would like to wait, at least read it. I know.
Representative Aldridge.
Would it be proper to ask our county attorney his opinion on this?
He's like, no.
What I can tell you is that Representative Silver is correct, and the privilege is yours to waive or not to waive. If you decide to waive it, it would make these public. I think lawyers tend to be very conservative and try not to let their legal opinions and theories come out. Having not seen them, it's difficult for me to know whether there's anything in there that would be prejudicial to the county. So it's very difficult for me to really comment on it, but that's, I think, the position. Thank you.
Representative Lang.
Thank you. So, I guess I'm reminded of some representatives in this room that actually put a bill in for the city of Laconia because they entered into a private agreement to buy a piece of property and then didn't want to release the documents. And the reason they ran was because they wanted the release of those documents after the conclusion of the purchase of the property was done. And I kind of look at it the same way. We're looking at the same exact kind of thing, that we have a conclusion to a case, it's been dismissed with prejudice, and my former prosecutor experience tells me with prejudice means they can't bring it back, right? So any of the documentation that's in here relative to the suit against Gunstock is irrelevant to any future case because they can't bring the case back. And if we think the city of Laconia should release the information about the purchase of, I think it was the church, then we should be voting in favor of this as well. When we talk about privilege, you're right, when we talk in terms of attorneys, the privilege is ours. However, the privilege that's really ours is that we serve our citizens, and we just spent $40,000 of money, so I didn't know well why.
Here, here.
You know, it was mentioned that we didn't get the unredacted bills from the attorneys to the GAC. It seems to me that we could put a motion to get those. No?
Sure you could.
Interesting concept. We can certainly ask the Gunstock Area Commission to
get those, to do that. That's how we can get those.
Representative Silver.
In the cover memorandum that was provided by counsel, the underlying section says, any decision to divulge the invoices or any other contents to anyone other than members of the convention must be made by the convention, not individual representatives, which is the substance of Representative Bean's motion. This confidential memorandum was produced by counsel. At my request, I indicated to counsel that many members of the delegation wanted to see the unredacted bills, and that we needed to provide that. So they provided this confidential memorandum, which sets forth the conservative lawyer's position that bills that indicate strategy and lawyer's impressions and things like that are privileged work product or attorney-client privilege. But the privilege is the convention's to waive. And essentially what this motion by Representative Bean is to waive the privilege. And in fact, I intend to vote in favor of the motion.
Further discussion? Is the clerk ready to call the roll?
Okay, I'm ready. Representative Howard.
Yes.
Representative Aldridge.
Yes.
Representative Boyd.
Yes.
Representative Bean.
Yes.
Representative Bobby Willio. Yes.
Yes.
Representative Johnson? Yes. Representative Lang?
Yes.
Representative Littlefield?
Yes.
Representative Mackey?
Yes.
Representative O'Hara?
Yes.
Representative Bourget?
Yes.
Representative Silver?
Yes.
Representative Terry?
Yes.
Representative Chartier?
Yes.
Representative Barney?
Yes.
Representative Common yes. Mr. Chair?
Yes,
18-0.
unanimous.
Good.
Good thing we discussed that, all that. All right. We will move on to the selection of Gunstock Area Commission, and we'll open public comments. Motion.
I'd like to remove Representative Michael Sylvia and Silver from the delegation based on financial bounties.
One more time.
Moving to remove Representative Sylvia and Silver from delegation leadership based on financial bounties.
Okay. Second?
Second.
Representative Trotter. So the motion is to remove Representative Sylvia and Silver from leadership and for financial malfeasance. Discussion? Speak to your motion.
Thank you. So on November 16th, we made a motion to maximize the spending for $20,000 on this legal cost. And then we have our billing of $36,000, which is now $40,000 without approval from the delegation or any of its members. This sends us now a 200% increase. This body fund investigation committee to investigate county commissioners because they expended items above the county delegation budget. For that reason, I believe it's appropriate to remove Representative Sylvia from his chairmanship of delegation and Silver from his chairmanship of his position on the investigation committee.
Any further comments? Representative Lang.
So I guess this goes back to the question I asked, but how is it any different than what we're charging and accusing the purpose of the investigative committee of the commissioners? We had a budgeted amount, we had meetings in between when we went from $6,500 to $36,000, now $40,000, where anybody could have brought out, hey, by the way, we're overspending, and I'm telling you, this is the first opportunity I have to tell you that our numbers are too high, and those numbers aren't there. I know as now in the tech field, as a project manager, if I overspend my budget by over 100%, probably wouldn't have a job. Especially if I didn't tell my boss about it beforehand, or the people that had control of the purse strings. So I absolutely understand why Representative O'Hara made this motion. Again, it goes right back to, if you voted in favor of the criminal investigative committee for the purposes of, investigative committee, because the county commissioners overexpended a line item, which was food for the nursing home, then I don't know how you cannot vote this.
Further comments? Representative Dean.
Well, I don't know, I think you just made the case to not do it. What did we do to the commissioners? Nothing.
I know the investigative committee is still supposed to be meeting, you're not doing it.
Hold on, this is not.
It appears to me that nothing was done to them for overexpending. That seems to set a precedent to me. And, I mean, there's a problem with it, I agree, but we did nothing to them, and I don't think we should do anything to them. That's my opinion.
Representative Harvey Polio.
Thank you, Mr. Chair. Doesn't malfeasance, imply intent
Yes.
of, malicious wrongdoing? Perhaps those aren't the right words, but it sounds like it's possible that this was an accidental overexpenditure.
That's it.
Representative Barney.
Yeah, I deal with the town attorney a lot in my regular job, and we never get the fees right. The towns always run over on their legal fees because it's a guess at how much you're gonna do a year. That's why we have contingency funds in municipalities, for the same reason, for over expenditures of unforeseen expenses, particularly in the defense. It would be different if it was an offensive case, it was a defensive case, so we have no control over what's spent.
Representative Boards.
So my concern with this is we're gonna spend up to $5,000 investigating the commissioners, which we appropriate. How do we know that $5,000 doesn't turn into $40,000? or 50. If we don't have faith in people to alert the delegation when we're going over expenses, the same way we want to know what they do with their line items, I just have no faith that we're gonna know what's going on.
Further comments before Representative O'Hara gets a second bite?
I'm not taking this, but I just wanted to respond to Representative Barnett.
Well, Representative Terry.
I was unaware that this motion was gonna be brought this evening. This is a very serious charge. I understand the allegations that have been made. I don't believe that the parties involved have had any opportunity to know what the motion was going to be prior to this evening, and they've had no opportunity to prepare any kind of response or defense. I'm not comfortable voting on this tonight. This is not, I'm not comfortable. It's way too fast.
Further comments? Representative Comstock.
Is the motion to table?
Second motion to table.
Well, did somebody make a motion? Nobody made a motion, or didn't make a motion?
Representative Comstock moves table. Representative O'Hara seconded. Yes, well,
Not debatable. It's a table.
not debatable. So the motion is to table the motion to unseat myself and Representative Silver. You got that, Representative Howard?
No, talking about IT, I think we ought to find a replacement because this is horrible. I'm getting so much background noise, I can hear everybody whisper and cough and sneeze. It's awful.
The way you stated the motion was that you'd be unseated from the delegation. I don't believe that.
But, so it's a motion to table.
Motion to table.
To table the motion, yes.
Yeah.
Remove Russell Silver and Sylvia from leadership positions.
Yes.
Okay.
All right, Representative Howard, do you get the motion?
So
Motion to table.
this is a table, this is a tabling motion, right?
Yes.
Okay.
Is that a yes?
Yes.
Rep. Aldridge?
No.
Rep. Boards?
Yes.
Rep. Beans?
Yes.
Rep. Hobby-Lilja?
Yes.
Rep. Huff?
Yes.
Rep. Johnson?
Yes.
Rep. Lang?
No.
Rep. Littlefield?
No.
Rep. Mackey?
No.
Rep. O'Hara?
Second.
I know.
Rep.
I
Puget?
was thinking something real quick.
Yes.
Rep. Silver?
No.
Rep. Terry?
Yes.
Rep. Troyer?
No.
Rep. Bonnie?
Yes.
Rep. Comtois, yes, Mr. Chair.
No.
Motion passes 11-7.
All right, can we move on to gun stop?
Crop TV.